hereby inform the Honourable Court that I'm withdrawing as the counsel of accused 1 to 4.
The instructing attorney for accused numbers 1 to 4 says he had no idea that Advocate Malisela Tefo was planning to quit.
So what happens now? Who will be representing the accused moving forward?
My instructions are that I must proceed to run the matter. I'll be in court. Whether I receive death threats, whether they tap my phone, doesn't matter. Because all of us, we are walking in the shadow of death.
It's a year ago, almost to the day, that I found myself sucked into this whole story of the Senzo Meyiwa case. I call myself now a social worker and a justice monitor because I am concerned that as a social worker I can't do my job unless the legal system works. And it's not working. And the best window that we can get into that's dysfunctionality is the Senzo Meyiwa trial. And it's not just the 5 accused on trial, it's the criminal justice system that's on trial. It's something you could hardly script in a Hollywood drama. But as a social worker, we always say, let's focus on the positives. Let's look for what can be changed. Let's work with what's going in the system. And I have to say, in the course of this year, I've been privileged to meet some really interesting people way out of my normal comfort zone. And one of them is attorney Timothy Thobane, who has found himself having to fill a vacant niche that was suddenly thrust upon him when Advocate Tefo withdrew as the representative accused 1 to 4. And we thought that would at least ensure that the trial would proceed. It was proceeding, but then it wasn't to be the end of the story. And it's not just, unfortunately, just a matter of entertainment and fantasy in a make-believe world of Hollywood. This is happening in South Africa on the ground. And what we're going to do now is just give Attorney Thobane the opportunity to explain and get behind the curtains, as it were, so that we can clarify certain issues that are potentially obstacles to the final resolution of the Senzo Meyiwa trial. I come as a social worker with the best interests of the most vulnerable and disadvantaged, which of course means the family of Senzo, his children, and for everybody concerned. I'm not a judge, so I'm not here to pass judgment. I'm here to try and develop deeper insight. So, Attorney Thobane, it's been one hang of a year for you in your professional career as an attorney. But before we get into the details, tell us a bit about yourself and why you chose law and how you got into this in the first place.
Thank you very much. Greetings to all. I grew up in a village called Marapiani, Skalpatfontein. And I went to school outside. At one stage in 1989, we went to Hombards town to buy groceries with my late uncle. He was just 1 year older than me. We bought big bags, like traveling bags, and he said he wanted to be a doctor, and I said I want to be a lawyer. And we went inside Wimpy to buy food, and we were not allowed to sit inside Wimpy. They said only white people must sit inside. Then we threw them with those food and walked out without even paying. Then that we left. Then my career continued like that, my life. I went to University of the North. I studied the BA law. Our president by that time was David Makura. When I went there, I wanted to study law, but they said, no, the space for law is full. You cannot do law according to the rules of the government. We need few numbers for Africans to do law. Then I was forced to do BA. I mixed it with some law subjects. Even though by that time I was doing BA law, there were also such funny rules to say in a year, a certain number of people must pass. They'll make you fail. They'll cut you down to say, no, you are not included in that number. You must repeat the model.
So it wasn't on merit, it was just simply on a statistic.
Yeah, the rule of the government of the day. They were taking instructions from the government of the day.
Which is the apartheid government.
Apartheid government. When I finished my BA law, I went to work at the post office. I worked in Sandton as a teller there. I worked for some quite long, and I joined the union. That's when I got interested in law. I started as a mail handler. You work for 4 hours, you put the mails inside the box. Then I left. I also applied to be an interpreter, part-time interpreter at the court. I started in Jamestown Court. That's when also interest in law came in. From there, I also volunteered as a police reservist. I was trained in Horton. I worked in Hillbrow Police Station, and also went further to work in Sandton Police Station, where I worked with Advocate Tefu there. That's where we met. After I've been working at the post office, I decided to stop working, went to study full-time with Vista University in Soweto, which was now known as University of Johannesburg. That's where I studied law. I did LLB. Then in that university, I was also in the SRC as a gender officer. Advocate Tefu was working at the SAPS national office. That's when he came to apply to study in the University of Soweto Vista. But they didn't want to take him, really, because he was working full-time. As an SRC member, I had to convince them to take him. They took him in. He studied as well. He studied, but whilst working.
While he was working in the police full-time as a police officer studying law.
Yes. After I finished my LLB, I went to Legal Aid South Africa and served articles there. That's when I got interest in criminal law, because I was in a criminal law section. Then I served my articles for 2 years and wrote my board exam as well. Passed my board exams, went to the law school, and when you write board exam, you will write also about ethics, which is done by attorneys.
Advocate Tefu then owes, to some extent, his legal career to you in having advocated on his behalf to be able to study law whilst being a full-time police officer. So that's when your relationship dates from. Fast forward now to 2022, and one gets the impression he's sort of thrown you under the bus to suddenly have to now handle a case. But how do you feel about where you are now in the light of that history? Because what I hear is somebody who was right from the word go wanting to see law as an instrument of social justice and fairness, not just as a means to make a lot of money.
My principle is to fight for justice all the time. Justice is a two-way phenomenon. It doesn't mean for only criminally accused people. It also involves the families of the victims. Yeah, and me and Tefu, I don't think he threw me under the bus. He owes me for helping him to study. The reason I'm saying so is that most of the time he was doing labor matters. Therefore, then I roped him in on criminal matters. And by the time when he was doing the matter, I still had the right of appearance in High Court. I just wanted to allow him to deal with the matter. That's what I can say.
Okay. So let's now go to where things are at the moment. Earlier, a couple of weeks ago, just when we thought things were going swimmingly, suddenly you heard that another attorney had come into the frame, Mr. Ramasapele, which rather led things to being a bit confused. And you only learned about the fact that two of your clients were now supposedly briefing another attorney minutes before the court rose. Take us behind the scenes.
Yes, I just want to put it very clear. There are things happening behind the scenes in this matter, which involves other people outside the courtroom and also other people inside the courtroom, the officers inside the courtroom. For instance, Attorney Ramasapele once approached me outside the court next to the LPC offices. Asked me that he wants me to give him accused number 2 to represent accused number 2. I said, I can't, I don't work like that. I need to get instructions from accused in order for the accused to be represented by another person or another advocate. If the accused says, Mr. Thobane, you must withdraw, I will withdraw. I am not going to give them instruction to say, appoint Ramosepile. That was the end of our discussion. Funny enough, the same week I was approached by Advocate Munisi, who also told me the same thing. He wants to represent accused number 2. Can I talk to accused number 2? And I said, as an attorney, I don't give instructions. I get instructions from the client. If the client says, I want advocate X or advocate Y, I will comply. Because it's the client who pays, not the attorney. Then our discussion ended there. At one stage, I received information that accused number 2 was approached by Advocate Munisi in prison, which is unethical and uncalled for. Hence, I'm saying ethics are very important in the profession. And advocates, I don't think they're studying ethics when they study there to become advocates. If they know ethics, they won't do what is happening in this matter. Especially Advocate Munisi, there's allegations that one of the advocates who were together in this matter in court sent Advocate Munisi to accused number 2. They never succeeded. Then comes Ramosepile. Ramosepile, there is also allegations that he was sent by one of the advocates who was in this matter. That's when he came in without informing us, giving us a hint that he will be on record. After that, it transpired that the same evening or the same week, accused number 2 informed Ramosepile that he doesn't need him anymore. So this matter might even be delayed further on the 2nd of May. Advocate for the state, Advocate Baloyi, in the manner in which he's handling the matter, that doesn't convince me that he understands ethics. You can't keep on giving attorneys exhibits in the middle of the trial. You're supposed to have given them at the beginning of the trial.
Yeah, let's just explain, because of the 5 accused, accused number 2 has not got any prior convictions.
1 and 2.
1 and 2,
Yes.
Okay. He's been held without bail, been given to him. Let's focus on that bail story, because that seems to me a terrible travesty of justice.
To be frank enough, I think Honorable Justice Letwawa, AJP, put it very clear and correct to say, why all this time accused number 2 didn't apply for bail? It is his right. He's supposed to have applied for bail, even if the matter was in a lower court. It is the attorney's duty to ask the client if he needs bail. So the attorneys who were representing accused number 2 by that time, they never did that. And my understanding that those attorneys were either instructed by legal aid or they were working for legal aid. I must say that legal aid South Africa is a good institution. It has resources. It needs someone who can work, who works hard and dedicated. There's nothing you cannot get in legal aid with regard to law. So it depends on an individual how they are dedicated to their work. I cannot blame the institution, but I blame the person who was helping accused number 2. You should have asked the accused number 2 whether you want bail or not. Whether the matter is a murder or theft or shoplifting, the bail is the right of the accused.
So that's a question you're holding his feet to the fire and saying, why did you not, as your ethical obligation as a lawyer, practicing lawyer, to ensure that the client's best interests are paramount? And the first one, in terms of the Constitution, is the right to bail.
Is the right to apply.
The right
to apply for bail.
Right.
Hence, we did apply. However, the state informed the court through its lead investigator that investigations are still outstanding, whereas the matter is already before the main trial, which means the state misled the Honorable Court that investigations were complete before the trial could begin. It is travesty of justice to wait for the outcome of a bail for over 4 months. We are not saying he will get bail or he will not get bail. At least if a decision is made on time, people out there, they will see that justice prevails.
So let's focus on that, because this goes to the heart of the legitimacy of the criminal justice system. Is justice being done here?
Justice must not only be done, but must be seen to be done, which means that in the eyes of the public, they must have hope that in this beautiful country, there is justice. Justice is very important in the legal profession for everyone. Justice is not about the accused persons or the victims of the deceased. It's a two-way traffic. It's not only about the families of the victim, but it's also include the accused people. Justice delayed is justice denied. This matter has been dragging, and it seems as if it's going to drag further, which will trample on the principle of justice.
And in fact, from my perspective, and I've said this a number of times and written about it, when justice gets delayed for so long, it becomes injustice compounded. Well, that's because people out there need to see justice as a deterrent to wrongdoing. So they're not seeing it done. It gives license to people to continue to break the law. The criminal justice system isn't somewhere out on another planet. It's embedded in our society. They say justice delayed is justice denied. But if it's delayed for so long, it becomes injustice compounded, because a whole generation of people have passed through and they haven't seen justice. It now becomes a case that people need closure. So what do? They develop a narrative, they develop a theory that gives them, at least psychologically, some sort of peace of mind that they can move on with their lives. So you're telling me that for 4 months, despite all the media coverage that has been focused on the Senzo Meyiwa trial, one of the accused has still not had a hearing for a bail application?
Yes, since it's been 4 months now. I applied for bail on the 13th, if I'm not wrong, on the 14th of October 2022. We are going into the new year without him getting the outcome of that application. That's injustice at its best.
Now, who's responsible for that? Is there anybody that we can name, or is it just part of the pathology, the sickness that's within the criminal justice system?
It is upon the presiding officer who deals with the matter to give a decision. It's not upon the attorney or upon the accused or upon the state. It is upon the presiding officer who handles the matter to make a decision on bail application. I think even the Judicial Service Commission must look at this, that how come a matter like this one being delayed for just a bail decision? It sets a wrong precedent. It sets a wrong precedent because this matter, it will be a precedent. Some presiding officer might use this as their precedent to say, in the matter of so and so, the matter was delayed for 5 months or 6 months just to make a decision. A decision was delayed for 5 months. They will be justified to do that because there is a precedent being created by this court to delay a decision on bail application, which is, to me, has found it unfair.
Well, the reason I'm feeling quite strongly about it is because I was actually assisting an accused in a bail application, several months ago. And the judge in that particular instance was extremely committed to ensuring that this man got justice. And there was urgency in that system. And now I see that there's people, because of all the other situation around this trial, people just are beginning to, their own confirmation bias kicks in and they start suspecting that there's some agenda. There's some deliberate agenda to actually undermine the system. Comment on that.
No, I think they are correct. There is underground tactics playing in this matter. The reason why I'm saying so is that they want the public to lose interest in the matter. And once the public lose interest, they know that they have at least one battle. It's a fact that in this matter, there are some people who are protected. And we are adamant that the accused before the court are wrong people to be charged for this matter.
That's right. So but I don't see the public losing interest. I mean, we've had Netflix documentary series. I've been filming this thing, and I've got my YouTube statistics have gone through the roof, which I'm very grateful for. At the same time, it's left me with a sense of, oh my gosh, is this ever going to come to some sort of integrity to resolve this issue?
It's a pity that the state, when I say the state, I mean the prosecution side, they use the court. They use the court to fulfill their other motives. For instance, the Criminal Procedure Act was developed during the apartheid era. The Criminal Procedure Act was meant to neutralize the public in some certain instances. The present prosecution, they use the same act that was used before. They use the same act to fulfill their own motives. There is a lot of things happening in this matter with regard to the prosecution. They know very well whom they're supposed to charge, and they're not doing that. They're using the Criminal Procedure Act to get away with murder.
So you say that there's a malicious abuse of legal process and legal procedure, of a Criminal Procedures Act, by an interest that has nothing to do with justice being seen to be done in this country. Is that what you're saying?
Yes, because what they do, they say the state is the monetus litis. The state is the one that must decide. Even though you can see there's a case there, they don't act because they have the right to say, no, we don't act there. They are abusing that principle. For instance, in this issue, there are two dockets. And they decided not to proceed with another docket. And it's a known fact that this docket before the court, at one stage it was closed. It comes from a cold case unit. Hence they called it a cold case. It was closed, this case, after they charged the wrong person again. That the guy who was washing cars of Kelly Kumar, they firstly arrested that person. After there was an ID parade, only to find out they arrested the wrong person. And they know what they're doing. They don't want to arrest the right people. They know who are the right people. Now they use the forum, the court, to play their own games. It's unfortunate that they are abusing the system.
Now the Constitutional Court has, I'm thrilled to say, because I was one of the defendants in that case, have ruled that slap suits are an abuse of legal process and improper motives are unacceptable to abuse the legal system. Now, they were talking about the civil litigation process. They were talking about this. You know, there's an Australian mining company who doesn't like criticism and is using civil litigation processes to tie us up. You know, the Constitutional Court has now said that's an abuse of process. And what I'm now worried you're telling me is that you're saying now that it's not only an Australian mining company that's abusing our legal process. And there was, interestingly, in the judgment, one of the judge writing it, Judge Magid, said, we might not have had the word slap suit, but we've had it for a long time in our justice system, that the improper motive, ulterior motive, has entered into a contamination of the rules and the procedures, so that, in a sense, things get rigged. Is that what you're saying?
Yes.
That is very serious.
That's very serious because they have a system on their hands. They can manipulate the system to the disadvantage of the vulnerable, the indigent. Let me use the word the indigent. For in case they are accused before the court, they are indigent, they are financially struggling, and they know and they knew that this will happen. Keep on postponing, frustrate them. At the end of the day, one of them might plead guilty. That's an abuse of the system.
Just to get over the thing, just say, well, look, for goodness sake, just do a deal, I see this in civil litigation at the moment as well with some of my whistleblower clients who find themselves tied up in processes of mediation which go on and on and on, whereas the client themselves are desperate. And they'll eventually take a lesser settlement just to get the thing over with. Whereas the guy with the money, they deliberately do that. And you're saying it's the same thing now happening, that there's like this intentional delay tactics, this playing things out, this what I call lawfare.
I agree with that, Honorable Justice, that in the criminal courts, that this type of tactic has been there for long. And it will take a miracle to put it to a stop, because they are manipulating it using the Criminal Procedure Act. Even when this matter started, I advised Advocate Tefo to tell Honorable Judge Maumela that we need assessors in this matter. It's not as simple as matter. Then Honorable Justice said, no, why you need assessors? Why you didn't say that from the beginning? Only to find out that Honorable Justice never started the matter. He shouldn't have done that. He never started the matter from the beginning. It was just another justice. It was before another justice. And the reason why I asked for assessors, I did it deliberately, so knowing that if he refuses, he says no assessors, at least it's on record. It is the right of the accused to request assessors. Then someone will say no, assessors only apply in regional courts. That's exactly my point, saying they're using the system to manipulate it. Hence, I even suggested at one point that let's use the American jury system. It's better. We cannot allow a single person to deal with complicated matters. Just like the Constitutional Court, there are over 9 judges in the Constitutional Court, justices, which is good. But litigation in South Africa is very expensive. If you don't have money, you'll suffer the consequences. Especially more now, in the High Court, they use something called online system, especially in civil matters and in appeal matters. They use online system. You file pile of documents online. If you don't have resources to do that, hard luck. It was expensive to go to Constitutional Court in the past, before they used online system. What I'm saying is, to litigate is expensive, and in the country, if you don't have financial resources, you suffer the consequences.
And the poor are the ones that suffer the most. And our Constitution has, in its preamble, an intention to actually see the equalization of society where everybody is equal before the law. What will it take, and how can we still pull the fat out the fire with this case? Is it possible that the Senzo Meyiwa trial could become the inflection point that changes the trajectory into the positive? What will it take for that to happen?
I think it is not only the Senzo Meyiwa murder trial that can change everything. It also in the hands of the authorities. They must make sure that these changes, as it stands now, the Senzo murder trial, it shows to everyone how there's no justice in this country.
So it's not just the 5 accused that is on trial, it's the criminal justice system that's on trial. We have had a year, 2022, that has been very disillusioning and disappointing. It has kind of ended on a somewhat positive note, and I say this because we've had former President Zuma now also abusing the legal process. To some extent, the state as a whole has been delegitimized, not just its components, by having a president who allowed the state to be captured, who is now using lawfare. They say in war, truth is the first casualty. And I've come to mind that when lawfare, truth becomes the hostage. And they use well-paid lawyers and judicial procedure to hold the truth hostage for as long as possible, because they know they're guilty. This is the paradox of it. And they play it out. And when I counsel people who are in trouble with the law, I always say to them, listen, just understand this. When the judge issues a verdict, if he finds you guilty, you were guilty from the moment the crime was committed, not from the moment that the judge handed down the verdict. And that often changes their mind and their attitude. So then they say, well, let's see if we can't deal with the truth of this matter in a more transformational and emancipatory way. How can we find some freedom?
I agree with you. We don't have a lot of freedom. And our justice framework has been thrown into the mud. For instance, NPA, the courts, they need independence from the state. They need to be independent, completely independent. As the issue of former President Jacob Zuma, I think they took it the long way. They should have waited for the NPA to charge whoever they want to charge, and if the NPA decide, no, we're not charging that person, then they will ask a knowledge prosecution certificate. It's unfortunate that the institutions in our country, they have interfered with each other. For instance, some of the decisions of the judiciary are questionable because they interfere with the arm of the state. For instance, in the issue of Janus Walus, the Constitutional Court doesn't have a right to say the state must release Walus, but they have the right to say, go and consider releasing Walus. Because it's not the court who must say that, because it is the decision of the Constitutional Correctional Services to make a ruling. Now they interfered in the duties of another arm of the state. With regard to the issue of Jacob Zuma as well, when the court ordered that the NPA must charge him, they interfered with the duties of the other arm of the state. That's unfortunate.
The issue for me, really, in drawing that parallel, was the question of truth. How are we going to get through the Senzo Meyiwa trial to the point where the truth does actually have an emancipatory effect, that it leads to closure? What is the truth? And what alternative ways are we going to get to it if it's not going to come through the adversarial criminal justice system?
It is unfortunate that the Netflix documentary interfered with that. It influenced the minds of other people. It affected on the point that the truth must be found. Netflix documentary caused a harm to these proceedings. And I can see that even this matter will be delayed even further because accused number 3 now has informed the state attorney that they have instructed Munisi. But Valoi informed me that accused number 3 instructed Munisi, Advocate Munisi, the same Advocate Munisi who I bumped with him on the other day, who asked me to come in. Now he went to number 3. Then on the 2nd of May, if he does come to court, there will be a postponement required. To make things worse, on the last appearances, on one of the days, Advocate Munisi did come to court, having a gown, roped, thinking that he will appear for accused number 2. What he did, he only went and greeted Advocate Mshololo and left. Then the following day comes Ramusipili. So they are also participating in the delay of this matter, these legal practitioners.
I'm not making any specific allegations, but we know that law costs money, and this trial's got a very high profile now. What is the motivation for suddenly we're seeing people popping up? Is it because of the public profile and to advance their careers?
I think it is about the public profile and also to cause harm to the process. Some, they have ulterior motives. They delayed, what they are doing, they are delaying this matter. And they will still delay it further. As I did say before, if there's no financial instructions, it's difficult to handle this kind of matter. And if I withdraw, I'll be not serving justice to the accused and to the families of the victim. Hence, at one stage, I requested crowdfunding to guard against whereby the accused are out of resources. Us as a law firm, we are out of resources to further go on this matter.
And the alternative would be going back to legal aid.
There's a rule in legal aid, which is unconstitutional, but I understand them. Once you are being offered a legal aid practitioner, and then you cancel that legal aid practitioner, you cannot go back again and say you want another legal aid practitioner. It doesn't sit well. Just sometimes they make an exception. But just like me, when I said accused 1 and 2, they have terminated my mandate. But next time when they come, they say they want me back to represent them, or maybe accused number 2 wants me to come back and represent him. It don't sit well with me. It will be unethical of me, but I will need convincing reasons to go back to him, because as it stands now, it's not proper for me to say no. When he comes back, I say, okay, I'll jump and okay, let me assist you. I have to make a serious consideration on that.
Most of them have got convictions for previous very serious offences. And therefore, they're fair game for people to play and manipulate them because there's this public prejudice against them, as there ought to be against criminals. We don't want criminals in our society. But we've got to be smarter than that. We've got to say, even criminals have rights. Let us be very wary of them being manipulated, supposedly in the interest of justice, whereas in actual fact it's undermining the whole legitimacy and credibility of the system.
Funny enough, those who have long sentences, they are not participating in any delay. Accused 3, 4, and 5. It just happened now that they claim that Muniz is going to represent accused 3. And whoever is doing this is just trying to use them, 3, 4, 5, to take the blame, to take the slap on the murder of Senzo Meyiwa, whereas they know who did it. And they know that this 3, 4, and 5, they're already serving long sentences. Even they get another 25 years on this matter, it won't have impact on them. The only people I'm really concerned with them is 1 and 2, because they don't have any convictions. But we must shy away from taking their rights. It is their right to choose whoever they want them to represent. And in them exercising that right, they must guard against delaying the matter and violating their own rights. Honorable Maumela once said, don't delay the matter in order to affect your rights. Make sure that when you delay the matter, you balance. You don't affect your rights and the rights of others. Because once you have a right, you have a duty to respect the rights of others. Rights, they don't just come on their own. They have duties and responsibilities as per our Constitution.
Any last word from you in terms of what else do you want the public to know through? I've just sensed a man of integrity in yourself, somebody who is finding yourself in a desperate situation, knowing that you don't want to undermine the rights of your clients and by not being able to appear for them. But at the same time, you are having to go out on a very brittle limb and you don't have any resources.
The public must know out there that whatever accused 1, 2, and 3 they're doing, it is within their rights. They can do that. And the most important thing is that the public must know that when attorneys represent people in court, they represent them to protect their rights. The duties of the attorneys is to make sure that the rights of the accused are respected. And it's not the duty of the legal practitioners to say the accused must not be found guilty or the accused must be found guilty. The duties of the legal practitioners is to stand up on behalf of the accused, because there are certain principles the accused don't know. It is the duty of the court to decide whether an accused person is guilty or not guilty based on the facts before the court. Just like when you do bail application. If you instruct an attorney to do a bail application for you, you pay an attorney. You give attorney financial instructions. The attorney goes there to represent you. You give attorney's instructions to represent you, to offer his services or her services to you, to spend their time on you, on the matter. It doesn't mean that when you financially instruct an attorney, it means you'll get what you want. It is in the hands of the court. The court is the one that must decide based on the facts, All of us, we go before the court to seek justice. All of us, when we go to court, we put trust in courts. We put trust in court that will get justice. Hence, the famous word used in court when referring to a male presiding officer in High Court, my lord. A female presiding officer, my lady. It doesn't sit well with me when you refer a presiding officer as my lord, because now you elevate that person to a certain level of Lord, God. And some of them, that word Lord, it goes into their mind and affect their normal thinking, the normal way of making decisions. I think our judicial system must be changed, and the word my lord be replaced by the word honorable or justice.
So what you're saying, I hear you saying, is that the idea of using that sort of antiquated term is almost to elevate that person into being beyond human.
Yes,
something larger than human. But
so that person thinks that, no, I cannot make mistake.
That's right, and they're infallible. It's
yes.
Bit, and then it goes to their head as they get too high on their own juice, as somebody says. They lose touch with reality. They become hubristic. They become disconnected. And it actually dehumanizes them as well.
Just for example, we are waiting for a bail decision over a period of 4 months.
Well, let's hope that 2023 is a year where we begin to see justice being done. And I hope that this little conversation I've had with my friend, Timothy Thobane, helps the court of public opinion, for those who are genuinely concerned about the future of this country, to think about what they can do. We've got the Judicial Service Commission, we've got Judges Matter, we've got instruments in our civil society for holding people accountable, we've got a good media set up, I've got this channel. I mean, we have freedom, and with that comes responsibility. In conclusion, I just want to say, a conversation I had 6 years ago, which will explain why I have taken up this cause, is with the former head of the Scorpions, Colonel Frank Dutton, who sadly passed away a year ago. And I went to see him after my friend and one of my clients, Bazuka Khadebe, had been shot and killed on the Wild Coast. He was the leader of the Amadiba Crisis Committee who were opposing the awarding of mining rights to an Australian mining company. Now, Bazuka Khadebe was a man who I'd known by then 10 years and seen somebody who, like Timothy Thobane and like so many other people, who are just simply wanting to see the right decision made and a just outcome that was fair to all concerned. The mining company weren't getting any traction from the community. Next thing, he got shot and killed. I explained this all to Frank Dutton and asked him for his advice as to what I could do in my role as a social worker to ensure that Bazuka's family could actually at least have some closure and see the perpetrators in court. And he said, John, I'm sorry, don't rely on the criminal justice system in this country. It's broken. Now, this was a former head of the Scorpions. I mean, not really a laughing matter, but you know the point. He said, rather use civil litigation by every means possible, because at least you then have more control over the process rather than having to entrust it to the state to ensure justice. It won't be the final justice, but it will at least ensure that some judicial process was ensued so that there could be some accountability and some ventilation of the facts of what actually happened. 6 years later, Bazuka Khadebe's killers have still not been apprehended. Senzo Meyiwa's trial about his accused have still not known. Still no closure. And I don't believe that that must be allowed to be the last word in the subject.
It is not only this matter whereby people didn't get justice. Many people got killed and there's no justice.
Yeah.
Or wrong people are being arrested and sent to jail. Their families must be taken care of. We need justice. Justice is justice. We need justice. For example, sorry, John, which is emotional. My father, when I was in Hillbrow, working at the police station, he was killed early in the morning going to work. Even now, the killers, they are nowhere to be found. That was in 1998. My uncle, Dr. John Mojo, the one I grew up with him, he was shot and killed next to Steve Biko Hospital. He was a doctor there. Until today, he was killed in 2012. Even now, justice has not arrived on his family and me as a part of the family, including his mother, my grandmother, who's now 96 years old. His father passed away waiting for justice. Funny enough, on a lighter note, when I grew up with him, my mom was at the university, and I shared the milk from my grandmother with him. We were fighting for the milk from her.
Yeah.
Yes.
Oh, well, I mean, you bring a human face to this whole thing, and I just thank you so much. The only retaliation I had to deal with was the fact that I got this defamation slap suit. And the judges have now ruled that that is an abusive process and have outlawed slap suits. But I won't be settled and satisfied until the criminal justice system is doing what it's meant to do, to ensure justice is not just done, but seen to be done, to ensure that justice does not get delayed so much that it becomes further injustice compounded.
Even this fundraising process, the monies that are raised, they might not even only be used in this matter. They can also be used to address other social ills out in our communities, because it is not only this matter whereby people didn't get justice. Many people. I just want to say that I also have a YouTube account, but it's just small. It's Timothy Thobane Attorneys. I'm humbly requesting that public out there assist us in securing justice in this matter by donations and crowdfunding where possibly they can. Thank you very much.
Good. Which Sinkobile Mapisa has opened a time bank account, she being the sister of one of the accused. And whether or not you believe on the innocence or guilt of any particular accused in the situation, it's not actually about them. This is about the criminal justice system. We need a functional criminal justice system in this country if our democracy is going to survive.